So, a very good afternoon to all of you. I am Dr. Bharti Singh, Area Chair, Economics and General Management, and I welcome you all to this session organized under the aegis of the Innovation Council of IMT CDL. So, as you are aware that the Innovation Council has been conducting a number of activities. All these activities aim at, say, building up your creativity. So it's also aiming to help you in coming out with ideas, problem solving, and startup incubation. Many of you would be aware that the recent past we had an event called Innovate X, and in this event there were a set of presentations that were made by many of you, and those presentations were basically in form of the concept notes that you had initially sent to us, and we had gone ahead with a process of presentations thereafter, after selecting a few of the concept notes that we believed had a promise to turn into startups in the future time period. So we all know that as a startup, intellectual property is very important, and you should be aware about the intellectual property rights, and so also how to say protect your IP. That is equally significant. In order to avoid any such kind of legal issues that your startup may face at a future time period, a sound knowledge of the intellectual property would help you in your further growth and scaling up of the organization. So today, Dr. Pratima Narayan would be helping us understand about, firstly, what is intellectual property right, and the IP management, the kind of strategies that you can undertake in your startup to protect and to say cash on the IP that you have. So Dr. Pratima Narayan is a legal consultant, and she is a qualified mediator and founder partner of Techlawlogi Consulting LLP. She is an expert in the areas of IT law, intellectual property rights, commercial contracts, consumer law, and alternative dispute resolution. She is involved in legal consulting and conducts trainings and workshops on e-commerce and law, intellectual property rights, ADR, and conflict management and communication. She has authored a book on electronic commerce, legal compliance. The book comprehensively outlines the various legal and regulatory frameworks and compliance for the e-commerce players. Dr. Pratima is also an empaneled mediator with the Indian Institute of Arbitration and Mediation, Indian Institute of Corporate Affairs and Summer. She has served the legal academia for over 2 decades as a visiting faculty at various reputed law schools and business schools. She holds a doctorate in law from National Law School of India, University, Bangalore. A dynamic legal entrepreneur, Dr. Pratima has pioneered an innovative dispute resolution system designed to streamline the process of determining compensation in commercial disputes. So today we will get a clarity from Dr. Pratima about what is the right time to consider the IP protection. What forms of IP do you need to have for your product or service? We will also delve in terms of how do we understand, how do we get to know that the kind of product or the idea that you have is new, or is there anything which already is there that exists from the previous innovations? How to leverage the IP to create value and drive growth, and what are the IP risks a startup should look out for. So taking all these questions in mind, and so also if you have any questions during the session that you have come across in your mind, you can put them over the chat mode. We'll take it up for discussion once we complete with the presentation of Dr. Pratima. So last 15 minutes or so, we'll go ahead with a discussion of your questions as well. So let's now understand from Dr. Pratima about intellectual property rights. So over to you, Dr. Pratima.
Thank you, Dr. Bharti, and thank you for the warm introduction. A very good afternoon, everyone. And the subject itself is quite interesting on the subject of intellectual property rights for startups. Uh, I'm sure many of you here have had a stint in terms of, coming up with new innovations. And Dr. Bharti was just mentioning that a lot of you have written concept notes and various other things. So I just want to take a moment to just understand from you all as to what has been your stint with intellectual property rights. Just maybe you can just come on chat box and just mention one or two instances and we can take the discussion forward.
So let's get quick responses from all
Just
of
one or
you.
two quick responses in terms of maybe you said you may say I have authored an article. Yeah, so some of you have a patent in your hand. Okay, excellent, excellent. All right. Do you have a patent? Do you own a patent, Mr. Ranjit? Okay, you have heard about it. No, I just want to understand if you have had a stint with intellectual property. Like maybe you can say, I have an innovative idea. I have a product development. I'm working on a product development, or I'm working on on a new software, or yeah, digital property. So you can very, very specifically tell me, or maybe you can as simply as possible, you can just say, I have authored an article, or I'm very good at photography. It could be just about anything, or you can say, I've come up with a new product design. Any stint that you have had by yourself, or if you have worked as a part of an organization and you have had an experience in your team in terms of building something new, or maybe a new brand building, a new logo that you came up with, or whatsoever. So any instances here of the sort?
You can talk about your organization as well. So if not as an individual, say if you're working in an organization, so any kind of such patent or trademarks or copyrights that your organization has taken in the recent past, so that you can share as well. So
Okay.
who is
So,
working on a
approved.
product? Yeah.
So currently the MVP stage. Perfect. All right,
Okay.
good. So, all right, let's dive deep into the subject of IPR now. What I'll do is I'll start my discussion with three important scenarios, okay? And I want you to tell me what is lacking in each of these scenarios, all right? So I'll start with the first scenario, scenario one. So this is situation one. This is an automobile company. I'm just taking this as an example. This is an automobile manufacturing company. All that this company has is skilled employees, good product placement mechanism. They have a good legal team, excellent sales team. But what they lack is innovation, both in terms of the manufacturing process and technology upgradation. They are running the same old technology, which has been like maybe 10 years old or whatsoever it is. So this is scenario one. Okay, please make a note of these situations. The same situation two, the automobile company. They have skilled employees, innovative technology, good legal team. But what they lack is a good sales team. What they lack is a bad product placement and apparently a bad market presence. Okay, this is situation two. I'm sure a lot of you would relate this to real-time situations. Situation three, the same automobile company that I'm talking about, which has skilled employees, innovative technology, great sales team, excellent product placement, good market presence, but they lack due diligence, compliance. They do not even know what innovation, how to protect their innovations. So these are the three scenarios. So what do you think is lacking in each of them? What do you think? You sort of had an understanding of the three situations. There was something lacking in each of them. I will probably just go back to the situation.
Yeah, just come back to situation one, and then let's wait for a few minutes for the students to participants to respond on it.
What's lacking in this situation? You can use the chat box very conveniently. I'm on the chat box as well. Yes, innovation. It lacks innovation. Absolutely. technology upgradations, innovations. So that is something which has to be constantly upgraded and innovated in organizations. What's situation 2? What's lacking here? Yes. What's lacking here? Market placement, right? They don't have a good sales team. So the management part of it is, there's something lacking in the management part of it. The first situation, there was a lacune in the technology. The second situation, so what is missing here is the good management. And the third scenario, I'm just getting to that. What is missing here? They have all of it, but yes, legal obligation handling. They don't know whether they are already infringing somebody's intellectual property. They don't do any due diligence check. They have not even considered filing an intellectual property or protecting their intellectual property. It could be anything, right? In terms of due diligence, compliances, etc. So I've just given it as due diligence compliance, but probably this could also include that they have a lot of technology, they have a lot of innovative technology, but they don't know how to protect. Jay, you bang on, you just very rightly said that. They don't know how to protect all of these, right? So what do we understand out of these three situations? There are three very important pillars to an organization. Number one, technology. Second, management, good management. And third is the legal compliance part of it. So all the three are very, very important pillars to an organization. Now, let me just take you through what is the rationale behind intellectual property. I would not want to go through another PPT study of A, B, C, D, E. It boosts growth, it boosts economic development, etc., etc. I just want to share this with you in a very pictorial format, right? Why intellectual property? Yeah, protect revenues from idea. All that is fine, but just take a look at this picture. What does it show? What does it indicate? There's a fabric, there's a basic fabric. You may want to call it silk fabric, you may want to call it a cotton fabric, you may want to call it as anything. If you are to convert the same fabric into a branded product, vis-a-vis converting the same fabric into a regular garment, okay, which goes into a wholesale store. So what holds more brand value? What holds more value economically, financial, monetary wise, by whatever name you want to call it as? It is the designer's work, right? The designer has put in, yes, designer has put in much more effort and skill in terms of bringing the best in the designs. Otherwise, everything is low technology. Everything is low end technology. Yes. Otherwise, everything else is low end technology, but it is the brand, the quality. Why would I want to go for a branded product? Why would I want to very specifically go for a car of this particular company or or an automobile manufacturing company? Because I understand the brand value of that organization. So it is for us to be developing all those in the times to come along with our business. Now, yes, absolutely. All your answers are bang on correct. Now, this is another example. These are all what you're seeing here in this picture is just the basic metal pipes. That's what you call as the low end technology. There is nothing in the metal pipe there. But what can you make out of these metal pipes? What can you make out of metal? You can make anything from as basic as bolts and nuts to making a luxury car, right? And if it is to be the luxury car and it has all the technology, look at the value of the product, right? That's where intellectual property comes in. Now, as simple as saying my mobile phone, my smartphone has n number of intellectual property in it, right? Maybe as simple as the technology behind the operating system. It could be the apps, the various apps. It could be the brand name. It could be just the design, the curve of the phone for which I purchased the phone. It could be the color of the phone for which I purchased the phone, right? It could be just about anything, which is all a value add to our products and services. This is where intellectual property lies. Yes, they show creativity through it. Absolutely. That's where all your creative, innovative ideas, all of them come out in the form of product or processes. Though you call intellectual property as an intangible asset to your organization, it has to come to you in the form of some tangible form, right? So it has to be the form of a product. It could be in the form of a process. It could be in the form of art. It could be just about anything, but it has to come out in a tangible form. So that's exactly what we are going to be discussing today. Now, usually what happens is whenever clients are to come to us saying, there are some very, very basic common questions. So I thought I'll pull out the top 5 questions, which are most asked in terms of the legal aspects of intellectual property rights. So just take a look at this. This is a very, very short case scenario. And we have just tried to put about 5 questions, which we want to take through the discussion forward. So here's you can just take about a minute to go through this particular slide. Please go through this. And we'll be discussing each question as we progress further. Okay. So let's keep this case scenario running at the back of our mind while we are exploring the different forms of intellectual property rights. Okay. So it is this company, that is EduTech, which has developed a software which is called Upgrad. And this has the potential to truncate the time in terms of computing, scoring, and grading, which is very, very essential for universities and educational institutions. So can you tell me, I'm not even going to the different forms of IPR, but can you tell me what are the forms of IP? If you are to prepare a comprehensive IP portfolio for a subject matter like this, what would be your thoughts? What are the kinds of intellectual properties you would want to consider here? Anyone who just want to give it a shot? You can quickly type it on the chat box. Could you please elaborate on that? What is this OCR? Copyright. Okay, optical character reading. Technology. Okay, good. Thanks for that. That's more technical, but under what category would you want to protect that, Tamin? So I see someone called KB. KB says it can be protected as a copyright. The software program can be protected as a copyright. Absolutely, right. Good. Likewise, the technology behind this optical character reading, yes. What can you protect it as? Like you must have heard of something called patents, trademarks, copyrights, designs, and various other things. So under what category would you think you can bring them? EduTech is also looking at a comprehensive IP. It's not just one form of IP that they are looking at. There may be different components to this one computing material. Any others? Technology patents, absolutely fantastic. You can register as a patent. You could also consider a copyright protection to it. Anything else? Any other component of this product that can be protected as IP? Patent, yes, they can consider patent. Yes. Anything else? If you were to be advising formula, okay. Trademark, yes. There's a name given to that product and they want to call it upgrade and they want to be very distinct in the market. So you might want to consider a trademark as well. Good. So it could be patents, trademarks, copyrights, and that's exactly what we are going to try and explore in the next part of this session. Okay. So you must have heard of patents, trademarks, copyrights. Maybe some of you have heard of industrial design. So I'll just take you to the next part of the discussion. Usually all our intellectual property rights would lie under one of the major categories. You can bucket them under one of the major categories. One would be commercial innovations. It could be patents, designs, just about anything, okay? Or maybe some trade secret formula that you have invented or whatsoever. You can bucket them under commercial innovations. And the other being artistic and literary work. So all your research papers, your concept notes, your user manuals, photography, art, creative work, everything falls under the other bucket called artistic and literary work. Just take a look at this slide. How many of you are familiar with all of these forms? Or if you're familiar with very particular forms of these IP, you can just quickly chat. You can let me know, yes, we've heard of all these forms of intellectual properties, or we're very familiar with, yeah, trademarks, copyrights, trademark and patents. So you can just very quickly type that we mostly know all of these. Very good. Or we have at least heard about these forms of intellectual property rights. Now, there's another question. We call it intellectual property rights. It's like a bouquet. It's like a bundle of certain rights, isn't it? It's not just one. It is different forms of intellectual property. So you have patents, you have trademarks, you have copyrights, and there are some contemporary forms which have developed over the times called semiconductors, plant varieties, etc. Okay, I'll be
Yeah,
discussing all of these.
Dr. Pratima, there is one question like KB has to mention he does not know anything about plant variety protection.
Yes, yes. I'll be talking about each of these forms. Okay. My
Okay.
next couple of slides is going to be dealing with each of these forms of intellectual property, and they're going to give you a brief introduction to each of these. Yes. Patents, trademarks, copyrights, and know-how. Yes. All of these we'll be discussing anyway. We'll go to each
Okay.
component of these, right? So these are the different forms. If you can just imagine this to be like a bouquet of intellectual property rights. You have all of them on your plate. You can choose one or many of them to create your IP portfolio. So the same example, let us go to EduTech company. So EduTech can pick up on saying that I want to have a patent for the technology part. I want to have a copyright for the software code that we have written. I want to have a trademark protection for the upgrade, right? So we can choose on whatever the forms of intellectual property that we want. But that's a major task, because the very first step to protecting your intellectual property is for you to identify the right form of intellectual property rights. You cannot just go to a design office and say, I want to protect my technology. You cannot just go to a trademark office and say, I want to protect my copyright work, or I want to protect a literary work, right? So these are all some things which we need to understand. By the time you are done with this session today, you have a very, very clear understanding and a demarking of each of these forms of intellectual property, and you are not going to mix one with the other. That's the whole thing. That's the first important thing that is going to be the takeaway for today. Now I'll just proceed to the subsequent ones. What is a patent? So even before you look at this slide, what do you have in mind of a patent? What is a patent according to you? Many of you have heard about it, and I'm sure some of you who also shared with me saying that you're working on a pharmaceutical patent or you're working on some technology patent in your organization. So what is a patent, basically? What do you mean by patent? In very simple words, just the way you know it. Okay, let us not use the word getting a copyright for an invention. Copyright is a different form of intellectual property and patent is a different one. Okay, so we are getting some kind of a right. Okay, we are getting some kind of an exclusive right on the invention. Let's call it that way. Own by yourself, yes, correct. You own something by yourself. You have done everything by yourself. You have come out with a new product. Good. Okay, fine. So if you look at this definition here now about what is a patent, it is basically an exclusive right. We call it exclusive right because you enjoy it for a certain term, which is called 20 years. Okay, so you enjoy some kind of exclusive right. That exclusive right also, I'll explain to you what exclusive right are you going to enjoy. Exclusive right which is granted to the patentee to either make, sell, or use the claimed invention. So if I came up with an invention, okay, let us say I came up with an invention. Let us say, let's take the same example of EduTech. We have come up with an invention, a technology invention for quick grading of scores or marks. So this technology, what can I do with this technology? I can use the technology myself, or I can license this technology across universities and I can be paid a royalty for it. Or I can simply sell away all these rights. Now, suppose my company is being taken over by another company, another edutech company or whatsoever. So I give away I transfer all my ownership to the other company, right? So that is the exclusive right I enjoy. It's as good as saying I have a house. What do I do with the house? That's also a property, right? What do I do with the house? I can either live in that house, or I can rent the house, or I can sell away the house. That's exactly what you get as an exclusivity, but that exclusivity is for a duration, that is 20 years. Now, if somebody is to ask you, or for your own understanding, patent is applicable to this. The second point is very, very important. Where is patent applied? Okay, they say patent is for application of an idea. Patent is granted to an application of an idea. So, where do you get that? It is granted to a new product or a process or an improvement of the existing product or process. Okay, so what you should have done is, in order to obtain a patent, you must have brought that in the form of a product. Product can be any product, maybe a technology in the car, or like we just discussed, a technology for grading. Okay, so it could be a product or even a process. Process can be anything. Like, for example, for those of you in the pharmaceutical industries, you understand that you came up with a new drug formula, or you came up with a new DNA sequencing. These are all what we call as processes. It can be in the form of a process. It is not only something new, product or process, it can also be an improvement of the existing product or process. Okay, it can be any of these things. So what happens after 20 years? After 20 years, these patents come into the public domain. The very reason why you are granted a patent is because there's something very interesting about it. You say you are an owner of a patent, right? But what actually you have done is you have disclosed your entire invention, okay, in the public in the form of what we call as patent specification. So because you have disclosed this, it is as good as saying, I have disclosed it, but nobody is going to copy it as is, right? But you can improve. There is scope for improvement on the existing product. Now, for example, I came up with, let us say there are a lot of sound systems in the market, right? My technology is better. It is improved because there is a 30% more noise cancellation compared to the other sound system products in the market. So I have improved on the existing sound system. That's what we mean by improvement. And that improvement has to be a substantial improvement. You cannot say, I just added, let's say there's a medicine component, a drug component, which has A, B, C components. I cannot just bring in a new D component, which has no relevance to it, and say, I have come out with something new. It has to be a substantial improvement. Okay. So I'll just take one or two questions and we quickly jump to this. Consider that I have a good technology idea or software. How do we decide we can patent? That's my next part of the discussion. So I'll come to that. I'll just hold on to that question.
Yeah,
Product means applicable for tangible item only or for intangible like software. Okay, so basically when you talk about software also, software programs are per se not patentable in India. Okay, what we are protecting as software or computer program is that it should be in an embedded form, or it should have some kind of a technical effect. Mere algorithms, mere software programs are not protected. So instead, software programs have a better protection under the copyright law. But if that software program has a technology effect, right? It is embedded in a hardware component and it is performing a different function, that is where you get a protection to something like this. Okay, I'll just hold on to the questions there. And I hope you're able to understand this, that patent is granted. Today onwards, you are very clear. What is patent granted for? It is for a product, it is for a process or an improvement of the product and process. There's something very interesting. The patent office, the Indian patent law, okay, defines the term invention. Now, coming to the second question, there's this question. Consider that I have a good technology idea or software. How can we decide what we can think can be patented and that no one has patented the same? That's a very, very relevant question, and your answer lies here. First of all, you need to understand what is the meaning of invention. What do we mean by invention? There's a very, very clear definition. And if you are having a pen and paper or anything, where you want to make a note of, I'm breaking this definition into three parts. Please make a note of those three parts. Okay. It says invention means a new product or process. That's number one. It has to be new product or process. Second point, involving an inventive step. That's the second part. And the third part is it should be capable of an industrial application. This is the definition of a patent. So all of you here who are innovators, who are working on different products and processes, who are looking at potential intellectual property, the first thing that should be running at the back of your mind, even before you ideate on something, would be ask these three questions to yourself. Is the idea new? Is there any novelty to this? Second, ask yourself the question, does it have an inventive step? How do I know whether there is an inventive step or not? How do I know I'm better? This is an improved version of an existing invention. How do I know that there exists something like this in the market? That happens through something called a patent search, or we call it as a prior art search. So usually patent agents would help you do a prior art search or a patent search to find that there is something which is already existing in the database of the patent offices globally. Okay, so you will have to identify whether now what is improvement on whatever is your existing invention. Now there are, like I gave you this example of sound systems, like maybe any of our headphones or whatsoever it is. There are multiple companies manufacturing headphones, and if my headphone claims that the quality of noise cancellation is 20 times better, or there is a 30% improvement in the existing quality, noise cancellation quality in the market, that is what I have to prove, and that becomes my inventive step. Or basically, there are umpteen number of such products in the market, but what my invention has done is that it has taken to the next level of the innovation. That's why you say disruptive technologies, or by whatever name you want to call them as, and there has to be an inventive step. The third most important question you have to ask yourself is, does it even have an industrial application? Where is it going to be applied? Where is it going to be used? Right? So that is the next question that you will have to ask yourself. Then another interesting thing is that the patent office, the patent law, the patent act has also come up with a definition called new invention. So it can be a new invention or an invention. Both are recognized under the patent law. So new invention has a definition here. It says new invention, it says new invention means any invention or technology which has not been anticipated by a publication. There has not been any publication so far on a subject matter like this, or used in any country or elsewhere in the world before the date of filing of the application with complete specification. That's what it says. So we have not heard of this technology. Even that is very, very capable of a patent protection. Even otherwise, if you just meet that test, the three tests, that you have, that can also be protected. I'm sorry, I missed on the chat box somewhere here.
Yeah, there is one question, Dr. Pratima.
Yeah.
Jay is asking what happens after 20 years. So if you get
Yeah,
a patent.
after 20 years, it comes into the public domain. Your pharmaceutical products, that's where you've been hearing of something called generic products. And India is a hub to manufacturing generic products, generic medicines. It just comes into the public domain. You don't have a protection after 20 years. The whole idea here is, innovation should continue. You cannot just keep having there are, of course, a lot of companies which talk about evergreening and other things. Not really so much of a subject for discussion today, but I don't know. I'm not able to see the the chat box. Yeah, I get that. Yes.
I'll post the questions to you, whatever questions are
That's
relevant during the session, Dr. Pratima. I think you
Yeah.
have answered all the three questions that were related to the content that is being shared right now.
Yeah. So I'll make it a little more clear. I have two more examples to talk about patent, and that will probably bring a lot more clarity about patents. Now, the question being, there was another question which EduTech had asked. How would I know whether my invention is is new, novel, and I can protect it as a patent? So this is what we call as the criteria for protection of patents. Okay. So we call it in very, very common terms, we call it as the NUN test, NUN test. That's exactly what I discussed with you as far as the definition of invention is concerned. So N stands for novelty, U stands for utility or capable of invention, industrial application, and the other N stands for non-obviousness, or what we call as the inventive step. That's what we discussed. Those were the three primary things that we discussed. Apart from that, and this is something which every patent office across the globe would consider as an examination, as a criteria to see whether your subject matter can be protected or not. And the fourth criteria is it is very country specific. So each country has its own patent law, and that country provides for subject matter which can be accepted for patent. In India, we have a very negative section. That is, it says what inventions are not patentable or what are not inventions. That's the definition you will see. What inventions are not patentable? So there are about 18 items, one of them being software program per se, which is not patentable, traditional knowledge not patentable. There are certain other things, mere admixtures and various other things. So these are all, there's a list of what is not patentable in India. This is what we call as the criteria for protection. Just on the lighter side, I'll take you through two simple examples or case studies just to show you how this NUN test would be applied, and that patenting is not all about rocket science. Patenting is about making lives simpler. Okay, so here's one illustration. I think a lot of you have seen these tiles. What are they called? They're called tactiles. I don't know, you must have seen them in public places, maybe metro stations or any other public places, right? Now, this is an invention. About 55, 60 years back, a Japanese inventor came up with this invention. All of us know tiles. Tiles has been common and it has been in the market for ages. But what this particular Japanese inventor did was that he came up with something called tactiles, which wanted to, where the idea was to bring inclusivity in public places. Now, the tiles that you're seeing here, the yellow tiles that you see in all public places, is for to help the visually impaired persons to be able to navigate their path in public places. All he did was just this. Those which are those striped lines is good to walk, and those with dotted lines are dangerous. You have to change your path. If you start observing them in the public places, this is exactly what you would see. Now, isn't this a beautiful invention? This was done some 55 years back, right? Now, what is more important? What is the key takeaway for us out of this invention is these are all some things which are used in our everyday lives. But inventors come up with something new, something innovative. They meet the NUN test, that novelty, inventive step. So do you see novelty here? Apparently, it was very, very new. The idea was new. Utility, very much used in public places. Non-obviousness or the inventive step, there are tiles, umpteen number of tiles, anti-skid tiles and 101 kinds of tiles you talk about, but this was a slightly different one which had an inventive step. That's the story about these stingy blocks, or what we call as stack tiles today. Another illustration about patents is this. Many years back, we all had cans of Coca-Cola, like what you see on your left, the image on the left, right? So the inventor of this, what we call as the ring can opener, what you're seeing on the right is the small technology is called a ring can opener. Okay. The inventor one day was on a vacation with his family with these Coke bottles, with these Coke cans. What the inventor had forgotten was to carry the ring opener, or the can opener. They had to have another device to carry along with them. And because he was not carrying the can opener, it was very difficult for them to open that can. So he comes back from his vacation, tries to work around some model, and came up with a very, very simple technology of having a can opener along with that cap. This itself was a patented subject matter. What you're seeing as the ring can opener is a patented subject matter, and he was able to sell this invention to Coca-Cola for like millions of dollars. Now, that's the value of intellectual property, and that's where intellectual property comes. These are all some things we find in our everyday lives. Okay, so these are two simple examples about invention, and more importantly, that these are all some things which ease lives, right? So that is the whole idea here. So that's about patents. I'll probably take one question on, yeah, I'll just come back to that.
Sagar Kumar
Yeah.
has put up a question. If we are trying to do a patent, do we really need to keep the end-to-end example, meaning if a software with complete code, how we implement the idea, or it can be just an idea?
Okay, so there are two, just to give you an understanding of this. So what happens is most of the time we may not have to come to with an end-to-end application of it. We may have ideated something, put that in some tangible form, but it's going to take us quite some time to, sort of develop the product. But what you can certainly do is, it's a very relevant question. What you can certainly do is, you can apply to the patent office with a basic specification. At least that specification should have the main features of your invention. You know the features of your invention. So you can just put all of that. And sometimes we also call it as a provisional filing. Sometimes, now let's take an example with me. I came up with an invention and I want to present this invention at a seminar or a conference, or, I want to showcase this at an exhibition or an event. So instead of me just taking it there, what I do is I give a brief introduction about my invention, submit it as a provisional filing. I get something called an application number. Please understand, we have a rule called, I'm just typing it here also for your understanding. It's called the first to file rule. You must have been the first one to get a priority if you have filed the application first before the patent office. They get a priority over the others who are filing for similar patents. Okay, so because it's a first to file rule, you don't have to worry to what extent your idea has been, implemented, or that you have worked upon the idea. You may continue to be working on the idea, but if the basic idea is, you have the basic idea, you have something in place, you are able to visualize something end to end, what it is going to, what is the end product, or what is the end result that this particular component or process is going to provide, you can as well go and file for a patent, and you can continue to work on the patent. The good thing about patent is you also have something called addition, patent of addition. We have something called divisional patents. You can do a lot of things around this patent. Okay. I'll come to the trade name in just some time now. We have to protect the trade name. This is okay. I'll just talk about that. Okay. So these are all about patents. The second one that I'm going to be talking about is trademark. Now, this is a very, very, very common form of intellectual property right. So what does the role, what is the job of a trademark? The trademark protects a mark or a logo which has to be identified, that you're using this mark or logo to identify your goods and services from that of others in the market, right? So the basic idea or the basic purpose, the underlying principle of a trademark is that it helps you identify your goods and services from that of the others. Okay, so it makes you distinct. It usually comes to you in the form of word, logo, color, designs, and various other things. But these are pretty much the forms of trademarks that we have. They also include service marks, collective marks, etc. But most importantly, for all of you who are trying to work around having brand names, developing brands, creating brand names and logos, I want to insist upon three important Ds that you should remember. Remember the three Ds before you plan your branding, before you plan working on a logo, before you plan a name for your product or whatsoever it is. The very first thing is you should be able to distinguish. Okay, distinguish your goods from that of the other. If your goods are kept in the market which are similar to the other goods, then you could be in for a liability. So you should be able to very clearly distinguish your goods from the rest of the others. It should not be descriptive. Don't come up with names. You cannot, sell apples for apples. You cannot have a name called Apple, okay, and sell apples. So it's as simple as that. It cannot be descriptive. The third one is it should not be deceptive. Okay, it should not be with an intent that maybe phonetically similar words or whatsoever it is, which makes it. Suppose there is something called MTR, ready to eat foods, and I come up with something called NTR, ready to eat foods. Okay, they are very phonetically similar. So these are some things which can deceive the public of similar goods and services, including the packaging. So it could be any of these things if they are likely to cause any kind of a confusion. The main test that we apply when we talk about any of these trademark infringements is whether the logo or the trade name of this particular mark is likely to cause a confusion to the public. So that is something which we have to very clearly establish. Okay, so that's about trademark. What is most important, due to paucity of time, I will have to just explain what these forms are, but you can delve a little deeper into it. There was one question, maybe I can just take that question right away relating to trademarks. It says, just a moment.
Yeah, Vinayak has to ask. We have to protect the trade name or form. This no one should use by prefixing or suffixing to this name. So there's a specific name and there is some suffix or prefix added to that name.
Yeah, so some, suffix and prefix sometimes may not matter, because if you say make my trip and ease my trip, okay, my trip, all those things are, they're all common English terminologies. Or book my show was there. Now book my buy, book my book, so many things, book my, so many things can happen. So these prefixes and suffixes may not really matter, but if they have established a goodwill for a very long time, then in such cases, they might, in all probabilities, not allow prefixes and suffixes. So it is very subjective. It depends on what is the likelihood of confusion. That's what I have been telling you, right? So maybe per se, if I look at it, I would say make my trip and ease my trip are both existing, right? That my trip may not matter, or trip need not matter. But overall picture that you give is what really matters. Okay, basically words not matched with product already have. Yes, that's the whole idea, right? They should not match the product. It should not be very descriptive in nature. That's what we would look at. So yeah, I hope I've answered that question. Now moving on to the next one, that is copyright. So I hope you're familiar with what is a patent now, what is a trademark now. Patent is all about recognizing the application of an idea. Trademark is all about identifying goods and services from that of others. The third one and the most common form of intellectual property is copyrights. Whether, say, you have written a research article, whether maybe you have written a user manual, maybe you have written a training manual, or whatsoever it is, all of these fall into the category of copyrights. So what does copyright protect? What does copyright do? It protects the work of authorship and artistic work from unauthorized use, right? It should not be an unauthorized use. What is unauthorized use? Making use of these copyright work without the consent of the owner of the copyright. So that's what it means. And generally, in the Indian context, our copyrights are classified under 6 very, very, very broad groups. That's what you see in the next point. It could be literary work, artistic work, musical work, dramatic, cinematograph films, or it could be sound recording. It falls under one of these categories for sure. And the most important thing about copyrights is it lies in the expression, not the idea. What does that mean? You cannot just say, I have an idea. You cannot just say, I cannot just narrate a story. Let's take an example. I narrate a story to Dr. Bharti, and Dr. Bharti makes a cinematograph film out of it. So who gets a copyright? Is it myself or Dr. Bharti? I'm claiming against Dr. Bharti, saying that, no, the idea was given by me. I gave you this idea, or I narrated this story to you. So who gets the copyright? Okay. It would be Dr. Bharti, because she has put that in a tangible form. Okay, so copyright lies in the expression. She has expressed it in the form of a cinematograph film. I did not express, I just had an idea, right? And I have expressed the idea, I've just narrated the idea. So I have to bring this intangible idea into a tangible form. Yes, copyright is used in films. Okay, so she gets the right to over the copyright over the subject matter. That's how we work around, and that's what we mean by copyright lies in the expression, not the idea. And the common mantra of copyright is copyright, whatever is worth copying is worth protecting. You can protect that work, is what is said. And then, what are the rights of an author? Now, suppose you are the author, or suppose you are the owner of a copyright. Let's take an example. You have written a book, you have written a novel. So, what are the rights that you have on that particular work? Okay, you have a right to communicate, right to distribute, right to reproduce, translate, adapt, or abridge. Communicate, I can communicate my work in the public. I can distribute my work. I can reproduce the work. I can make multiple copies of my work. I can translate my work, or if I don't know some other language, I can give that license to translate to someone else. But I retain the translation right. Adapt, right to adapt. What is adaptation? Suppose a novel. So I have written a novel and Dr. Bharti converts that novel into a cinematograph film. It is a right to adaptation for which Dr. Bharti will have to take a sort of a license from me in order to convert that into a film. And abridgment. What is abridgment? Cutting the long story short. So maybe Dr. Bharti wants to bring that novel of mine in the form of a short story, which maybe children can also read about it. Okay, so that is what we call as right to abridging. These are what we call as the economic rights of an author. So whatever copyright that you come up with, you can use it in all these forms. These are all the rights, that bundle of rights that you enjoy as a copyright holder. Okay.
Jay has a question. So if you summarize, when you talk about right to abridge,
Yeah.
so Jay has put up a comment summary. So is summary acceptable as a
Yes, absolutely. That's all summarizing. Absolutely. So suppose I have come up with a book and you write a summarized version of that book, right? Or an abridged version or a short. I'm just saying, cut the long story short. You are coming up with a shorter version of what I have written. You make it far easier for others to be able to read it. So that is the abridged version of the work. But for that, you will have to obtain the permission of the author. You cannot just say, okay, I will make a summary of it. I'll do an abridged version of it and I will sell that. And all these are the questions come when we are going to commercialize these works. It's okay to just have that, summary of the work or whatsoever it is. Keep it for my purpose, keep it for my private use, or keep it for my educational purpose. It's all perfectly all right. But the moment I start commercializing this, I need to obtain the permission from the author of the book or owner of the copyright work. Okay, so this is all about copyrights. And then you have the next category. Okay, under copyrights, there are three main things that you need to consider. When would you get a copyright? You get a copyright on your original expression. Okay. Second, you must have fixed it. You must have brought that copyright, that idea, like in terms of maybe a story or whatsoever it is. You have to bring that story in the form of a book, a novel, or some tangible form. So that is what we call as fixation. You have to fix that idea in some tangible form. And the third one is skill and labor. Okay, you must have applied some amount of skill and labor to say that I have contributed to this work. So these are the three things which would be important for you to determine copyrights in your work. So that's about copyrights. Then moving on to industrial designs. This is another interesting feature. Now, as you all know, a lot of companies, a lot of organizations, and maybe your own organizations are very keen on packaging and giving the best to the customer. You have to package your articles, right? So skill and labor is you have applied your skills, like suppose in terms of writing a work, doing some kind of a work. You might derive some work. Now suppose there are several books, let us say on epic, right? Mahabharat. Okay, you write a commentary on Mahabharat and I also write a commentary on Mahabharat, and both of us are claiming copyrights. Both of us can claim copyrights based on the skill and labor. I have come out with my own idea and I have put it in the tangible form. You have come out with your own idea and put that in a tangible form. So that is the skill and labor you have applied, the skill and labor that I have applied. Okay, so that's what it means. All these questions come when there is a copyright infringement. So how much skill and labor did you apply to your work? Was it a complete copyright work? You have just copied somebody else's work. That's what it means. I hope that answers your question. Yeah. So talking about industrial designs, we spend a lot of R&D, just coming up with design of the product. Okay. So for example, design of a packaging box, design of wallpapers, design of a car, design of the mobile phone. I want to buy a mobile phone simply because the curves of that mobile phone is so beautiful. Or I simply want to buy a car because of the design of the car. It has a very, very aesthetic look, right? So there is a very specific protection to design, which is called industrial designs. And what it does is it identifies the aesthetic or ornamental character of the product. How beautiful the product looks, how aesthetic the product looks, how ornamental is the product. That is what is taken into consideration. Technical features or functional characters are out of the window. We don't consider any of those things. We don't consider technical features. We are only interested in the aesthetic look. I'll give you one example. Just take a look at this. Both these are keys. For which of these would you want to give a design protection? Both have grooves. You are seeing grooves here and you are seeing grooves here also, right? Okay. So KB says it is mainly for the grooves. This also has some aesthetic grooves. This also has some aesthetic grooves. There is a novelty in the head and this also has some novelty, right? But what you're seeing on the right side, it is a design and it is designed to look good. Sometimes you want to, flaunt a key itself, which looks very nice. Here, the grooves of this key are also looking very aesthetic. They are also looking very nice, but they are used for a particular purpose. It has to fit that lock, which is why these grooves were done. It is not, it is more functional than calling it, aesthetic. So you need to be watchful that it is for the aesthetic look of the work of that particular product that you are given a design protection. Okay, so that is what we mean by industrial design. So you're spending a lot of your time, effort, energy, and money in terms of coming up with aesthetic look for your product, which is a very, very critical thing. Otherwise, our mobile phones, each of our mobile phones are of different color or of different design and various other things, right? Okay, looks like there's a question. Can I just progress further and then come back to this, or let me see.
Actually, the question is regarding, say, if a patent, trademark, kind of intellectual property was not taken by the concerned person. So, what is the loss which would be there?
Yeah, very
Eh,
good question. I have an answer to this slightly later. I'm just talking about the forms of IP. There is
mm.
something called an IP risk I'll talk about. Okay, so
So,
there I think I
yeah,
will definitely answer this question. I'll
so
just hold
Kumar,
this question for a while.
yeah, Mr. Ravi, I would request you to please wait for a few minutes to get an answer to your question.
Yes, a very relevant question. I'll come back to that in just some time. Okay. So these were the four forms which are very, very common in our industry practices, in our organizational practices. There is something else in the market, in the global market, where we recognize products mainly because of their geographical origins. Okay, which is what we call as the GI or the geographical indication of goods. There is something called the GI tags, the GI marks that we see today. The purpose of the and this GI is not given to you and I as individuals. Okay, I cannot say I belong to Delhi and there's something very special about my product. No, I cannot say that. It is given to a community of producers, growers, etc. Now, what if, just imagine if tea that is grown in Munnar is also called Darjeeling tea in the international market. Darjeeling tea has its own flavor. Darjeeling tea has its own uniqueness and it is globally renowned, right? So if how do you recognize these kind of products which are grown naturally, which are grown through agricultural produce, which are grown through manufacture? Like for example, if every handicraft was to be called Rajasthani handicraft, right? Or if every shawl was to be called a Pashmina shawl, there would not have been a difference in terms of the uniqueness of that particular place and the kind of product that we get or the produce that we get from there. Or if every orange was to be called Nagpur orange, which is why in the international market, we try to identify them through some tag. which is what we call as the GI tag, the GI number, there's a particular mark or something which you identify. So that is what we call as the geographical indications. Each of our states, each of our countries, we all have our own uniqueness. And the uniqueness, as you see the next point here, it is used to identify goods and services, and develop reputation as far as that particular market is concerned. That is what we call as the GI tags. The next time you come across any of these products, you can watch out for the GI tag, right? Maybe Darjeeling tea or whatsoever it is, they print the GI tags, the GI numbers, or a mark or a logo or whatsoever it is, which will help you recognize the authentic products in the market. And the GI is given to you only because of the topography. The quality of that product is because of the topography of that product in the market. And it is usually in the form of agricultural goods, natural produce, or even manufactured goods. Okay, so that's about geographical indications. The next one is, these are the contemporary forms of intellectual property, which we call as semiconductor and integrated circuits. So basically what they are doing is, this is very popular in the semiconductor industry, where you have different layers of the semiconductor chip, right? The integrated circuit. So each layer can be protected. The semiconductor layer, the topography of the integrated circuit, all of these can be protected. We call it a sui generis system, which means a separate system. Sui generis means a separate system to protect only the topography. Otherwise, the semiconductor chip is doing something. The technology behind it is taken care of by the patent, but simply the topography, the integrated circuit design is what is protected under this category of intellectual property rights. That's about semiconductors. Next is protection of plant varieties. One of you had asked me, okay, what is this plant variety all about? So this is also called, there is a particular enactment to this on the plant variety. We also call it the farmer's rights or the breeder's rights. In India, we don't have anything like a patent protection for new and improved agriculture or horticulture. But there's, as you would be seeing, that there are a lot of genetically modified food that we have in the market, hybrid varieties of seeds and plants that we have in the market. Every day, farmers and breeders are coming up with new ideas, new innovations in the space of agriculture, horticulture. They're coming up with new plant varieties, new food varieties for us, and they need to be incentivized. So that is the reason why we have, again, a separate system of law which protects only the plant varieties. Okay, so that's about plant variety protection. Trade secrets. Now, this is something which is very, very, very common. You might probably think, if you talk about trade secret, it is probably applicable only to something like a Coca-Cola formula, or it is something which is very applicable to a food, a KFC's, particular food product. It's not necessarily only in terms of formula or a food product. It could be anything relating to your organization. For example, your software itself may have certain parts of the code which are a trade secret. If that is revealed, everything else is revealed. Right? So there are certain components you want to keep it to yourself and you don't want it to be revealed. It could be sales methods, these are just some simple examples that I've given you. But it is completely left to the organization or to the startup entity to determine what is a trade secret. Okay, maybe the data that you have, the way in which you have created your consumer profile is very unique to your organization. You may want to protect that. The list of suppliers, the manufacturing process, there may be something which is very, very unique to your organization and you want to keep that as a trade secret. How do you protect that? You don't have a registration process. The moment you register something, you have to disclose it. So you cannot register it. So how are you going to protect that? Through confidentiality. Okay. Or maybe if you're revealing that to a few persons or key persons in the organization, you may have to have a robust confidentiality and non-compete clause or something of that sort. And that's how you protect trade secrets. Okay, so this is also one of the forms of intellectual properties. Now, we have answered two primary questions. So if I can go back to EduTech's question, just anchoring that question. Number one, what are the forms of intellectual properties I have? Second, how do I identify whether my invention is good for patent protection, for a protection, right? Now, the third one, How do I leverage? There was one more question. I'll just very quickly go to that. Sorry. I'll just very quickly go to this. So when is the right time to protect? Now, this is the most important one. The second question, I'm just focusing on the second question. When is the right time to protect? So given all of these, I will just get to this. So given all of these forms of intellectual property, this will give you a sort of a fair answer to it. Now, if you talk about trademarks and copyrights, you don't really have a registration process. It's not like a first to file rule or something of that sort. So you can keep them on hold. You can file them at a little later date. Maybe, and copyrights, the good thing about copyrights is the moment you have come up with a copyright work, it is protected. There's an automatic protection to it. You don't have to worry too much about going to a copyright office and having it registered, provided you feel it's worth copying and you want to get it protected. That's perfectly all right. Even with trademarks, unless you feel that the branding has to start from day one, you don't have to really worry about it. You might probably start with your venture, take it some time, and then consider a trademark protection. But that does not happen with your innovations. If it is a patent, rush to the patent office because it's a first to file rule. You must be the first one to have filed for a patent. If you think that your innovation is worth protecting, go ahead and just go ahead and file it. Industrial designs, geographical indication semiconductor, you're not focusing very much on that. Again, very important, trade secret. Though it is not something to be registered, but if you feel that there are certain things which are confidential in your organization, just keep the confidentiality going. Okay, maybe even at the early stage of your startup, you have developed a data set, and that's very critical to the organization. You have to start protecting it right from there. Okay, trade secrets are something which you can protect right from the beginning, and you've got to be extremely watchful about it. So these are some things, which you can go in a gradation, and there's nothing like a thumb rule which says you have to protect it right from this particular date or whatever it is. Startups will have to start considering the IP portfolio. That's where we say some are formal intellectual properties like patents, trademarks, etc. Some of them are informal. Like, for example, you have trade secrets, know-how, and confidentiality. These are all some things which you can keep that confidentiality going right from the beginning.
Ravi has put up
Okay.
a very interesting question, Dr. Pratima. So, according to
Yeah.
Ravi, regarding the trade secrets, consider if KFC is keeping a trade secret and providing the same to a cook who works in KFC. Can that cook use the same to his own company?
Okay. So what we need to understand here is any of these organizations, if they are to call it a trade secret, they will not give the major, like for example, I'll give an example in a very simple way. Okay. Suppose I'll put it slightly different. Maybe it'll answer this question also. My grandmother used to make pickle. She made very good pickle, and it was very, very authentic. The taste was very authentic. So I learned that pickle making from my grandmother. And I started making similar ones and I distributed to a couple of them. They found that it was a very, very unique taste. It had a very unique taste. So I want to commercialize this manufacturing or making of pickle, producing pickle. So what I do is I cannot do all of these myself because I have to go on a large scale. So I appoint 10 people to make the pickles. What if I have to keep the trade secret? If I taught each one of them, so pickle making, you cut the mango in a particular way, you put salt in a particular way, all that is very common to everyone. But what was most important in my pickle was the masala. There was some key component. If I gave that away to my employees, each of my employee would go and do his own business. So what I do is I give them that masala, but I don't teach them how to make it. I hope this answers your KFC question also, right? That's how it is done. The basic ingredients, you all know the basic ingredients, but you don't know what quantity you put into what, right? What is the measurement? What you all know ingredients, but what goes into the ingredient, what component goes into it, none of us know. If you
Okay, then.
do that, you are
Okay.
maintaining your trade secret forever. But if you gave that cook the KFC, the work, the trade secret, tomorrow morning there will be another KFC or SFC or TFC or whatever. There will be many more FCs which will come up. So that is the concept of trade secret. Instead of giving you this example, I gave you a very, very layperson's example. Okay, so that is the concept of trade secrets. So you don't reveal the most important part of the business. That's why you say USP or whatever, by whatever name you want to call it as. If I give this away, everything is gone. There you've got to maintain that secret. So it is only the founders who will know, or very, very few in the organization who will know that component of it. Right? Otherwise, if there is something which has been disclosed, also it has to be very strongly guarded by confidentiality agreements and various other things. Dr. Bharti, it's slightly out of time, but can I continue? I just have 3 more slides.
Yeah, so
I'll probably
next
take only
5
3 to 4
minutes or so.
minutes.
Yeah,
Yeah, I'll
because
close it in the
questions
next 1 minute.
have been answered on the go. So
Yeah,
I think another 2-3 minutes to wind up, and then if anybody has any question, they can start posting the question right now on the chat mode so that we can take it later as well. So you can
sure,
continue for next few minutes.
sure. Thank you. So we have answered 3 questions. The 4th question, how do I create value to my intellectual property? What do I do after taking a patent, trademark, copyright, design, or whatever name I want to call it as, right? I have to commercialize it. Otherwise, it just goes into a cold storage. So what are the different ways in which we are generally commercializing our intellectual property? So we either license the intellectual property for which we are paid a royalty, or we just assign it, we just give it away, we transfer all our rights in the intellectual property to some other party, and that's where the intellectual property rights is sold and we get certain commercialization to that. Employment, independent contractor agreements. So there is something that if you are employees with the organization, you have an IP clause which says how you deal with the employee, the IP of the company. Independent direct contractor agreements. Freelancers, a lot of freelancers work for organizations. So who owns the IP? How do we work around the IP? What would be the IP valuation sharing, the commercializations, commercials sharing? All of these are dealt with in your employment independent contractor agreements. You could be getting into joint ventures, collaboration agreements, technology transfers, know-how, technical assistance agreements, development agreements, franchise agreements. These are all just a few examples that I'm telling you in terms of how you leverage branding agreements, right? So if you see the sports, the leagues that happen today, there's a lot of branding that is happening around. That also happens through branding agreements, branding, sponsorship agreements, etc., etc. So these are all the different ways in which you commercialize your intellectual property and you generate revenues out of it. Ultimately, you should be able to generate value to the organization. And the larger your IP portfolio, the better it is in terms of the valuation of the organization as well. Right. So this is the concept of commercialization. Again, due to paucity of time, I'm just touching upon these aspects. The next one, the last question we had to sort of consider, and I think there's also a question regarding this. What if I did not consider my intellectual property? What if I thought that it's not very important? Right? That was one of the questions asked.
Yeah, that
So
was put forward
if
by Mr.
yeah,
Ravi. Yeah.
yeah. So if I did not value my intellectual property, somebody else will take it. Tomorrow I may lose upon it, right? And I may be subject to infringement for my own idea. So that's where the first one is infringement, the IP related risks. So what should a startup do here? 2 things. Number one, respect your own intellectual property and respect the other intellectual property, the other's intellectual property. When you say respecting your own intellectual property, try and see what is protectable here of your given subject matter. Second, make sure through adequate legal help and various other things, just try to evaluate whether there is a product which is already existing in the market, because you do a lot of things and finally you see that there is already something which is existing in the market, or you come up with a trade name, brand name, or whatever it is, you think it is unique but it is already existing in the market, so you could be in for a trouble yourself. So respect your own intellectual property, respect the others intellectual property rights. If you are exporting goods outside of the country, there is something called freedom to operate analysis. It's always good to consider to get an FTO analysis done, because we need to understand whether that country has a patent to a subject matter which is similar to the product that I'm selling. So if I'm exporting certain goods from this country to maybe some other country, and there are inventors in that country who have similar products, they may hold you liable for coming up with such or exploring their markets. So that is where FTO analysis would come in very handy for exporters. Breach of confidentiality and trademark. This is something that you startups will have to continuously watch out for, right? Breach of confidentiality within your own organization and trade secrets. So you've got to take all the possible steps to maintain confidentiality, trade secrets within the organization, because you're all just picking up there, and all startups usually they come up with some really, really brilliant ideas. So that is something you have to maintain confidentiality of. The fourth one is there is always a possibility that the moment you bring something out into the market that is subject to counterfeiting and piracy related risks and issues. So you've got to watch the market continuously. Okay, it's a constant monitoring of the markets. Ignoring to protect your IP. That's where the answer comes to your question, Mr. Ravi, that if you ignore to protect your IP, somebody else may bank upon that. Okay, so somebody else may take that idea and commercialize on that. So it is always good to seek prior opinion to see whether the subject matter is protectable under IP or not. So these are some basic aspects that I just wanted to bring about. So these are the 5 questions I have tried to answer, and the most common questions that startups and entrepreneurs ask in the context of intellectual property rights. So I'm open to questions now. That's okay. So just a couple of things that startups could do: capture new ideas and innovations. Just a second. Yeah, so capture new ideas and innovations. Look at market exclusivity. How exclusive is your subject matter in the market. The most important thing, align intellectual property assets to your business strategies and goals. Conduct annual portfolio reviews. Continue IP asset training. So a continued IP asset training. It's not just that you should know, but the organization should know of it. Your employees should know of the importance of intellectual property, right? And respecting intellectual property rights, establishing IP policies, procedures, contacts in terms of how can I leverage intellectual property, where can I license it, how can I make use of it, or is there a potential for joint collaborations? These are all some things which are an ongoing thing that you could be doing. So that's it from me. Thank you, and open to questions.
Yeah, thank you, Dr. Pratima. There is a question that has been put forward by KB. So there are companies who are technology licensor, example production process of polyethylene, and they give license to other companies to produce the same. So what type of IP are these licensed? Is it patent or not?
Okay, so the technology behind these processes could be patentable. They may have been patented. So what the companies would have done is, having manufactured those or having ideated those, they give out something called non-exclusive licenses. So many of them can make use of this particular technology and use them in their further productions or whatsoever it is. So that is the way in which it is being used. So what type of IP are they licensing? It could be a patented product that they are licensing, the technology behind the product. And is it patentable or not? They may have patented it. I mean, it's not a hard and fast rule, but it may be a patented subject matter. Right? So when companies are interacting with each other, that's what they try to understand from each other. Is this a patented subject matter? Are you going to license to us? For how long are you going to license to us? Okay, who are the other licensees? Who are the other competitors in the market? So we establish all of these during our discussions while there is some kind of a licensing of this sort. Good question.
So I hope that gives you an answer. KB, if you still have a doubt, you can raise your doubt over the chat mode. So anyone else who has to get any clarity, you may please connect with the expert.
Yeah, I think there's one raise of hand. Sarath Kumar, you might want to just come on audio and you can ask your question. Ravi, I hope you can unmute.
Yes, I can unmute now.
Yes.
My question is, I patented something. Okay, the same kind of things someone is also doing, and he is growing. Is the other person is also good in his business with the same set of things, but I patented the things. Whether what I will get out of it, because I patented the things. The other one is running a business with the same kind of patent things. Will I get any benefit out of it, or how it will be?
Okay, so basically what you're asking is what would amount to an infringement? That's probably something that you're trying to understand. I'm not understanding. There's some all kind of a thing. Okay. So the question here is, I have a patented subject matter, and if somebody else comes up with a similar product or a slightly improved product, and he's selling it and he's marketing it, what is my right? Is that what you're asking?
Yeah, I think Mr. Ravi has a patent on that particular.
So, yeah, if you have a patent and if you find that a similar product is being, manufactured by a competitor, you can always file for an infringement. Again, this is very subjective. It all depends on what is the nature of the product and how much of it is a copied version of the existing product. That's where I told you first to file system. You must have been the first to file and you must have got the patent to it. I hope that answers your question.
Mr. Ravi, if you still want some clarity from the expert, so let us know. You can send a mail to the IIC email ID, and then we can get you connected with the expert for further questions that you have. There is.
Okay, Dharmendra has a question.
Yeah.
Please come
Yes.
on, unmute yourself and ask me the question.
Yeah, thank you, Dr. Pratima. Yeah, so I have two questions. I think one of the question was in the chat about patent. What happens after 20 years?
So all patents fall into the public domain. Public domain as in to say, see, the whole idea of a patent is this. It is like an open letter. So the moment you say, I want to get something patented, the incentive that you have is the patent. But what you are doing is you are disclosing your entire invention to the public. Okay, so you're giving a complete specification about your product, including the workflow, the diagrams and various other things, which are all out open in the public. But what patent does is it protects you from infringement for the next 20 years. Nobody can copy a similar invention for the next 20 years. But after 20 years, you don't have a right over the same thing. That's what I gave you as an example of generic drugs. What becomes a generic drug? There's a patent which is a patented subject matter, a patented medicine of a company in the US, and 20 years has expired. And by the time the 20 years expires, there are a lot of generic manufacturers who take upon that idea and start manufacturing them in bulk. So this patent owner loses his right to claim against the others. That's what I mean. That's what I mean as public domain, something that comes into the public domain. It has a life, it has a shelf life. Patent has a shelf life of 20 years. 20 years from when? 20 years from the date of filing the application of your patent.
I hope this clarifies, Mr. Dharmen. And
did you have a second question, or maybe due to paucity of time, you could just write to us sometime of any other queries that you have, Mr. Dharmendra?
please share your concerns on the IIC email ID. So anyone who wants to get a clarity further on the topic that we have discussed today, you're all welcome to send your queries over the IIC email ID. We'll share the email ID with you as well. And there's one quick question that we want to take. Ram Kishore Yadav has to ask, how much fund would require to register? So the amount of fee that you have to pay. That is what I think Ram Kishore Yadav is asking Dr. Pratima. So that takes care of the session for today. And any queries that you have, come back with your queries on the IIC email ID. And so also there is a feedback form that has been shared with all of you. I request you to fill this feedback form So I hope a lot of clarity must have come to you regarding the usefulness of a patent. What is, how do you get to get a patent, or what is the none test? What is a trademark? What are the 3Ds that you need to keep in mind? What is an industrial design? And what is GI tags, and so on and so forth. So a lot of detailed discussion has been done on the various forms of IP, and that when you are planning your startup and you go ahead with your startup, you would be always able to relate to whatever has been discussed today during your conceptualization of the particular startup. You face any such kind of concern, you have questions in mind, come back to us on the innovation council. So there is one quick question, Dr. Pratima. It is regarding Mr. Ram Kishore, who has to ask, how much funds would you require to register?
Yeah, so I was just coming to that. There is about, so if you look at Startup India initiatives, and if you are registered under startup or as an MSME, if you have an Udyog Aadhaar card, you get something like up to about 80% rebate in terms of the patent filing fee or a trademark filing fee. But it depends on the attorney that you connect with, okay? And they have their own filing fees and drafting of complete specific. The major requirement here when it comes to patent is patent search and drafting of your patent application. So that is the more expensive part. So that could run. I mean, it depends completely on what is the fee that the professional fee in these circumstances. But otherwise, talking about the government filing fee, etc., they have certain concessions in Startup India initiative, and you will find all those.
So I hope almost all questions have been covered during this session. And these are primary questions. So definitely, when you go ahead with your venture, then new questions may come to your mind. For that, also, you can come back to the Innovation Council of IMT CDL. And thank you, Dr. Pratima. You have very lucidly explained the various terminologies and what kind of criteria, what kind of test that has to be undertaken to go ahead with any of these intellectual property forms and such instances that you have, the examples that you have taken up. So the students from these simple examples would have understood the significance and the value of an intellectual property. So thank you for being here, Dr. Pratima, and we'll be connecting with you whenever required on this subject. And thank you to all the participants who have been interactive throughout the session and made it more engaging and helpful to all the people who are here today. So thank you and goodbye. So Innovation Council will be conducting more such expert sessions and other events and activities for your benefit. Thank you and goodbye to all of you.